one for insurance that is in some retail installment contracts and is not in others. I've seen it go both ways, and that's the use of the funds paid out by the insurance company. Sometimes, even though a dealer is, or a finance company or whatever lien holder is listed as lost payee, sometimes nonetheless the insurance company will still send the payment to the customer, or will send the payment to the customer and the check will say customer and lost payee, right? Whoever that company is. But the customer will nonetheless endorse it and just keep the money. Somehow the bank messes up, doesn't take a second signature, customer commits a fraud. I mean, there are a ton of different reasons why that could happen. I've seen a lot of them in my practice. Here's the thing. Contracts, the best ones I've seen in retail installment contracts, have a provision that says that the customer is required to either get the dealer approval to use the funds or is required to use the funds to repair the vehicle, right? It's not always clear that the vehicle has to be repaired with those funds. If there's no obligation to do that, then the customer could say, well, this damage isn't so bad. I'll take my $2,000 check from insurance, go spend it on something else, and just drive around with a damaged car. That's obviously a big problem for the lien holder, because when the lien holder gets the car back, if they do by repo, let's say there's a default, or for whatever reason they end up, let's say the customer trades it in, it's worth much, much less. And so the dealer's going to have a bigger deficiency claim against the customer. And we'll get into deficiency as well when we get into litigation. So just something to be aware of there, that it's best if there's a provision in the retail installment contract that notifies the customer that they have a duty and obligates them by contract to use the insurance funds to repair the vehicle.